The federal government has ramped up its fight with the state of California over transgender athletes. Today, the Justice Department filed suit accusing the state of violating Title IX by allowing transgender athletes to compete on girls' teams. A state law allowing students to participate in programs and use bathrooms that align with their gender identity has been on the books here in California for more than a decade.
And for more on this, we are joined by David Levine, professor at UC College of the Law. David, thanks so much for joining us this afternoon. Let's just start with how strong this argument is in the lawsuit that the state of California is violating Title IX, which bars sex-based discrimination in any education program or activity that receives federal funding.
Sure, Christina, this has gone back and forth now sometime. The Biden administration tried to pass Title IX interpretation that went exactly the opposite way, saying that gender would be included within the word sex. And the really strong argument in favor of the state's claim at this point is that back in 2020, Justice Gorsuch wrote an opinion under the Title VII portion of the Civil Rights Act of 1964. And of course, we're talking about Title IX today. Both of them use the word sex. Justice Gorsuch, in the employment context, said that sex includes gender identification, as well as sexual orientation under the word sex. So if we're going to use the same word in the same statute, then the state of California is on pretty firm ground. Now, some courts have said, oh, they're different. Title VII is different from Title IX, but we haven't had anything definitive from the U.S. Supreme Court. And there is a case that is pending in front of the court from West Virginia, which they will be hearing in the fall, which really raises the same issue about Title IX. Whether or not the word sex includes gender or not. So really, until we get guidance from the U.S. Supreme Court, it's hard to know which way this case that was filed today is actually going to go. But I think the state has a pretty good argument. And you might recall they already filed a case under the 14th Amendment several weeks ago up here in San Francisco, which is pending in front of Judge Breyer. Now, that one is only the 14th Amendment question. And I think one thing that might happen is those two cases, the one from Anaheim and the one from San Francisco, might get put together as one case so that it could all be resolved efficiently in one place. But the state has a pretty good argument. That's the bottom line.
Yeah, okay. So what happens next here in this process here? The state of California is hit with this lawsuit from the U.S. Department of Justice. The state obviously has denied violating civil rights laws, but what kind of a legal response do we now get from the state of California?
A couple different ways to go, Alex. One possibility is I think the state has to decide if they want to ask to consolidate these two cases. Judge Breyer is hearing the constitutional case up in Northern California. So one possibility might be to say Breyer's case was first filed and ask the judge in the federal judge in Anaheim, who hasn't been assigned yet, we don't know which judge it is yet, and just ask for a transfer of the newer case up to San Francisco. So that's one possibility. Another possibility would be to try to move fairly quickly with perhaps asking for a preliminary injunction to get the case in Anaheim resolved relatively quickly, because we don't really have a real factual dispute here. It's really a pure legal issue.
And
administration? I'm sorry.
And David, let me ask you: would the state ask for that preliminary injunction because of the concerns about being cut off from the federal funding? Because that is one of the implications.
That would be a big part of it, right? You don't want that. You don't want that money, the education money writ large, let alone Title IX money, taken away in the interim. So it would be pretty important to make sure that the funding is secured while the case gets resolved, and whether it's resolved in Southern California or Northern California, or the courts decide to wait until the U.S. Supreme Court weighs in on really an identical issue later on. But you're quite right that the state does not want to find itself without the money coming in because of this dispute about what is the correct interpretation of Title IX, something that has ping-ponged back and forth. It is not free from doubt either way.
Okay, David, quickly here, we don't have very much time left, but I'm just curious your thoughts because Governor Newsom had previously said that it is unfair to have women and girls compete with transgender athletes. In the past, within the last few weeks, I believe he said it on a podcast, and I'm just curious, it seems that Pam Bondi is using his words against him to support this lawsuit. What kind of implications do you think his comments could have in court?
Well, I'm sure they would want to use it, but when the case was filed up in Northern California on the 14th Amendment, surely Governor Newsom signed off on that. The Attorney General would not have gone for that case if he weren't confident that the governor weren't behind it. And so I think that that can be resolved. The governor might say, I've got some concerns, but I think that state.
All right. It looks like we're losing our connection, unfortunately, with David Levine. So we'll leave the conversation right there. Always appreciate David coming on to share his insights with us.
Yeah, moving on here, search crews battle